Hey everyone, you're in for a wild ride today. And trust me, you won't want to miss this one. Eric Martin, our infamous sovereign citizen specialist, has somehow stumbled back into the courtroom, this time facing a brand new domestic violence charge. Sitting across from him is Judge Slovin, a no-nonsense authority who tolerates zero foolishness. From the very first words you hear, the chaos is already brewing, and you can tell this session is heading off the rails. Judge Slovin cuts through Eric's flimsy arguments like a hot knife through butter, delivering sharp comebacks and a few memorable zingers along the way. If you thought you'd seen it all before, think again. This courtroom showdown is intense, unpredictable, and utterly captivating. Buckle up, because things are about to get wild.
And observe all my rights before I cross this bar.
Sure. Let the record reflect that you are a living man, because dead men cannot speak. So, this is people of the state of Michigan versus Eric Martin. Today's date and time set for a free trial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me, if I may first, Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
First off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you do not want, and you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, not just him, any attorney, because I will not be allowing an attorney to turn me over to the court, the jurisdictional court, which is what they do. Is like normally.
All right. So you want to represent yourself? What you're saying?
Not represent myself, but present myself.
Represent yourself. Same thing, sir. Again, we're not going to play semantics like you did the other day. So
the law's based on
the same thing, sir. It's the same thing. Literally the same thing. Look at this source, present, represent, sure. All right, so if a motion is granted, you can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter. Because you have a constitutional right to do so, and you can. So, it's today's date and time set for pre-trial. So, Ms. Sobe, you have not had the opportunity or chance to speak with Mr. Martin, who is in full purpose. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you, I will set this case over and let you discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pre-trial the matter.
Before we get to that, Judge, I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great lengths, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there's a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact.
Honestly, are we really shocked here? Because I'm definitely not. This is a guy who's already faced domestic violence charges twice, yet somehow still thinks the Lord doesn't touch him. He treats a no-contact order like it's just a suggestion, then goes a step further by threatening the victim again. Pure recklessness piled on top of arrogance. This is exactly the kind of dangerous, entitled behavior you see when someone believes they are untouchable, completely above reality, and convinced the rules simply don't apply to them. It's reckless, it's infuriating, and it's exactly what keeps these courtroom battles explosive and unpredictable.
Complaining victim, to my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
Check the room right now.
He's been attempting to, but he is in the hospital, could not be here in person. He might have audio.
I think they're in the I got Kurt Martin in the check-in room. So if you want to zoom back in, or if you jump in back in on Zoom, Kurt Martin is in the check-in right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house, and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right to self-information, so we'll not be answering that question based on That, and also I was going to object to her, what she just mentioned. First, I want to mention, allegations that I'm there. That's not sufficient evidence that I actually am there. Yeah, number,
I'll just have a bond hearing, is what I'm saying.
well,
And then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
well, first of all, he ain't a true victim. So someone object to. First of all,
First off, listen, I'm not even going to entertain any of your stuff. This internet, Google, the internet type stuff that isn't even real or true. I mean, I've already ruled on most of your motions. I'm going to let you rule. I'm going to let you bring your motions again. I don't want to make rulings on them. But what I'm saying is, you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, "Oh, you're in violation." No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and your case just goes forward. It's as simple as that. It's called due process. So what I'm saying is, when she says you object, when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. It's just that's their job that's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by preponderance of the evidence that it is true that you violated the bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations, because that's all they are, is allegations.
so objection made based on the Constitution. No sufficient evidence if he lied.
You can almost feel the tension radiating from the judge as he firmly tells Eric, "You just don't get it. This isn't a casual chat or debate club. It's a bond hearing. There's no room for storytelling, endless objections, or treating the courtroom like a stage for his antics." Judge Slovin lays it out plain and simple. A bond violation hearing is looming, and it's entirely Eric's own doing, thanks to his refusal to follow even the most basic rules. When that day comes, Eric can spout all the pseudo-legal jargon he wants, but the judge isn't having any of it. Every word will be met with swift, sharp pushback, proving once again that in this courtroom, nonsense gets shut down faster than it can leave his mouth. It's tense, it's inevitable, and you can almost hear the frustration dripping from every sentence.
If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent, and anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off is I don't want you to step on your own constitutional toes. Everything you're saying can be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden they get to use that against you, because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay. I'll take your silence as an affirmative.
No,
So, well, you didn't say that you didn't understand, so
no, I do not understand.
you don't
I do
understand.
not stand under anything you're saying. So, but anyways, this is discussion for a moment.
From an English standpoint, you're not standing under anything. I didn't build a bridge. I didn't build.
Legally, it's not all
I
based
didn't put
on.
up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent. Anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Sov and have a pretrial in this matter, and then we'll deal with after the Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition here.
Thank you, Judge.
Also, I'll invite you to this is scheduled for a motions hearing tonight.
So the two of you can go out and have your pretrial.
My
I
demand
just told you go out in the hallway and have a pretrial. If you don't want to talk for it, don't talk. It's up to you. But what I'm saying is right now,
okay, I'll talk to five. I'm saying, but right now, I have these.
sure, you're not controlling these proceedings. I said, right now is the time for you and Ms. Sov to have a pretrial. If you're going to have a pretrial, we'll do that. I'm controlling cases. They call me from my court. Thank you very much.
It's clear that Judge Slovin has officially hit his limit with Eric Martin and his endless sovereign citizen theatrics. After that tense back and forth, Eric and the prosecutors step out for a pretrial conference, which, unsurprisingly, achieves absolutely nothing. The second they return to the courtroom, It's like clockwork. They dive right into another argument, this time over jurisdiction. And of course, with Eric, it's always the same exhausting pattern, circling back to the same old, tired script, full of defiance and pseudo-legal mumbo-jumbo. Watching it unfold is almost painful, yet you can't look away, because you know it's only going to escalate from here. The courtroom is practically vibrating with tension, and everyone can sense that patience is running dangerously thin.
Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you availed yourself of the jurisdiction. You live in Taylor. You enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction, and I find that your motion has no merit. Is denied.
All right, check to that. That's my argument. Article 3, Section 2 of the U.S. Constitution. That's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction. Well, the U.S. Supreme Court has original jurisdiction on Article 3, Section 2. And Article 3, Section 2 doesn't allow them as a reason to deny or to say that you have jurisdiction. They don't allow them.
For Article 3,
Especially they allow you to deny it.
again, your motion is denied. Article 3, Section 2 of the United States Constitution deals with one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan, and that's you. And so, living man, living trust, living CUA, whatever you want to call yourself, guy, Biggie, little G, I don't know, whatever, all that good stuff, Big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on going. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor. So the case is going to start here in Taylor. And so that's why I have jurisdiction over you for the reasons stated on the record. And just the obvious, the United States Constitution, Michigan Constitution, I have jurisdiction over this case. So that motion is.
As I've mentioned before, this isn't Judge Slovin's first encounter with a sovereign citizen, and it surely won't be his last. He knows the Constitution inside and out, and he's seen more than enough of these self-proclaimed legal experts to spot their patterns immediately. When someone thinks they've cracked the law after watching a few YouTube videos, the judge doesn't flinch. He dismantles every argument with precision, cutting through the nonsense like a pro. Watching him in action is like seeing experience meet authority. Calm, calculated, and completely unshakable. Every time Eric tries his tricks, Judge Slovin is already 3 steps ahead, leaving no room for theatrics or delays.
Set forth by the Michigan Supreme Court are the ones who specifically state that I can set bond conditions in order to do a couple of things. 1, to make sure that you appear at court. 2, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that can keep the 2 parties separated in time. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing, because one of the things I need to know is who owns the house, like legally owns the house. Because me, I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution. And why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or it's a victim. Whoever actually owns the house, I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house they don't even know. The victim will move. That's how that's going to work. So you want to check with the victims and see who actually owns the house.
My knowledge, I believe, is the mother's house, and they are brothers.
The mother is still alive?
To my knowledge.
Okay.
Is she alive?
So you talking about my sister, Lisa Martin? No, she always thinks that she owns it. She owns nothing.
Who owns the home?
Well,
I'll just look up the Wake County Register of Deeds. Council, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Under adverse, non-adverse possession law, because I've been living there minimum 15 years under that state statute.
No, you see, again,
I-
people, listen, you just have no law, but they have to really teach it this. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you're never, ever, ever gonna get adverse possession.
Adverse or non-adverse, okay?
There is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what, hey, whatever the bar exam you wanna take, you let me know, I'll study for that one too.
Honestly, I'm not buying for a second that Eric Martin is ready for a real intellectual showdown with Judge Slovin. While Eric seems convinced he can spar on legal theory, the judge is on a whole other level, clear, precise, and armed with decades of actual legal knowledge. Meanwhile, Eric is still lost in his own fantasy world, building arguments from YouTube videos and pseudo-legal theories like they hold any weight. It's not even close to a fair fight. Every attempt he makes to flex his legal genius is met with swift correction, leaving him floundering while Judge Slovin maintains complete control. Watching it unfold is equal parts frustrating and fascinating, as the stark contrast between real authority and amateur theatrics couldn't be more obvious.
But to answer your question, let me finish saying, I always want to try to cut.
No, because I want to wait till everybody's under hold.
Fair.
I'm just saying, I'm staying at that hearing. I want to know legally who owns the property.
No, someone's mentioned, no, we can do that too, I'm just saying, but it's always,
Oh, we're not ready to do that today.
Justin, it was always my parents, right? House, so to say, and I don't even think they really owned it because the mortgage wasn't paid off, so I don't think really, no one totally owns it.
Mortgage is a promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think we're actually, all of us at the house are possessors of law. My understanding of law is we're actually possessors. Because the bank really owns, because the mortgage is never paid off, my understanding. But it was always, so to say, our parents' house, like I said, I don't think they really owned it.
So here's what I'm going to do. I'm just going to go ahead and do a spontaneous look it up in the Wayne County Register of Deeds myself, because it's a matter of public knowledge. And then I'll take judicial notice of the fact who was the owner.
Well, like I said,
That's all I got to do.
adverse and non-adverse possession, MCL statute.
What we're going to do is we're going to have a hearing date. And that hearing date is going to be on the same date as the jury trial. So in the meantime,
I have a right to be there because I've been in the minimum.
did it say you?
My state
don't have a right to be there, so you don't own the property. You don't own the property.
Under that statute,
You don't own the property. So you need to vacate the premises because that's where the victim was. I told you no contact with the victim.
that's an unlawful void order because of violation.
But it's not.
Because without any evidence, you can't just say, I can't be at a house.
Listen, sir, I'm going to tell you one more time. I'm not going to sit here and argue with you. If you keep arguing with me in court here, I'm going to hold you in contempt because you're just holding up everybody else who's ready to go and proceed with their cases. And you just keep bringing up the same thing that isn't anything at all to bring up. I've already agreed with my ruling on your motion and denied your motion. I told you that you can't live in the same house with the victim in a domestic violence case. When I told you should have no contact with the victim. If you don't own the house, now if you own the house, they actually own the house, they show the deed that shows that you are the Wayne County Register of Deeds, that you're the owner. I'll make the victim move. Why? Because I'm not going to take somebody out of their own house. I'll make somebody else move, but it ain't going to be to that. But you don't own the house. Okay, so you're going to need to vacate the premises. You're going to need to vacate the premises.
Okay, my objective, like I said, is not just a deed whether someone owns it. Under the statute in Michigan, it mentioned.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I was going to grade. I'll give you a statute. You already know me. I cite MCLs all I know from. So I'm gonna give the MCL statute, but it deals with what's called non-adverse reverse possession. Okay, you live, one of the basic elements. You lived at a house for 15 years, right? Now, this is my parents' house, right? I've been here 30-something years. When you lived in a house that long, you are considered part owner, basically, you know. So, and therefore, a right to be living at that.
No, Eric, this isn't how any of this works. You don't suddenly own property rights just because you've been hanging around a place for 15 years. What he's fumbling toward is MCL 600.581, the statute that sets time limits for real property disputes, specifically subsection 4, which covers the 15-year period in adverse possession cases, basically dealing with squatters. But true to form, Eric has somehow twisted this into a bizarre argument that he should be allowed to stay on the property and keep harassing the victim, simply because he's been there long enough. It's the kind of logic only a sovereign citizen could present with a straight face, expecting anyone to take it seriously. Watching him try to justify this nonsense is equal parts frustrating and absurd, leaving the courtroom shaking its head at yet another ridiculous stunt.
So it ain't just whether you have a deed or not. That's it. Regardless of the ownership. Yes. No.
You have,
That's the whole thing. It's like,
after 30 days, if you stay in the premises with permission, after 30 days, you become a de facto month-to-month leaser. And you become a leasee at that point, and you have a lease with the property. That's it, at best. And that means you can stay there and they can evict you, or I can give you a bond order that says you need to vacate the premises.
It's
That's a court order. You don't own it. You don't get a possessory interest, but you don't get an ownership interest. There's an absolute difference.
No one owns it.
There's an absolute difference. Listen, I'm not arguing. Keep arguing with me, and I'm going to hold you in contempt. Because I'm telling you, you don't own the property. You have a possessory interest at best, because you've been there for 30 days, sure. And they can either evict you, or a bond condition can move you out. Either one. Or actually an injunction from the circuit court, for if there was a case, they have the power to move you out of there as well. There's 3 different scenarios where you could be moved out of there. One of them is bond condition. Bond condition says no contact with the victim. You don't own the house, get out. In the meantime, get out until the case is done. So if I find or know that you are there, I'm just telling you, I will hold you in contempt of court. I will remind you that contempt of court is a misdemeanor, punishable by 90 days in jail and or up to $1,000 in fines. And I'm just going to let you make sure that you are aware of that. Again, ask you, would you like any court-appointed attorney to help you in this case?
No. That's the word thing now. It's not part of my constitutional rights.
Just
now. The order, first of all, the bond order violates my due process, because you can't tell me to be out of the house, my house I've been living in all my life.
It is not your house. You keep saying your house, and it's not your house. It's the place that you were allowed to stay by your mom and daddy. But now they're no longer. This is not the situation anymore. It's not the situation. So you don't own the house. You're all grown up now. You don't.
I'm going to need a proper citation for that claim, because Eric suddenly acting like a responsible adult is nowhere in the record. But you hit the nail on the head when you told him bluntly that the only reason he even has a roof over his head is because his parents allow it. And honestly, that might be the most precise legal observation of the entire hearing. It cuts straight through all the smoke and mirrors has been spinning, laying bare the simple truth that no amount of pseudo-legal theatrics can change. His situation isn't earned. It's permitted. That moment alone says more about the hearing than hours of Eric rambling ever could.
The person who, and I'm telling you, you need to vacate the premises because the victim lives there. So you're going to vacate that premises. So your motion to set aside the bond conditions is denied. Because clearly you can't understand simple concepts that I'm trying to tell you. So I really don't want you to have in a position where you're in the same building with the victim. Because since these allegations are ones of violent nature, I don't want that to happen allegedly to the victim again. So your motion for jurisdiction is denied. Your motion to dismiss or set aside the bond conditions is denied. Let's see what else. You got a motion, copy. You already got a copy of the complaint, so I granted that. There's your copy of the complaint, and plus check your email. Counsel did say she sent you all the paper discovery. We're going to get you a copy of the rest of the discovery as well. And then you had a motion, which was basically the same motion as the other two, we just put all together into one. That says motion to dismiss because of lack of, you're challenging the standing? You're challenging the standing of the people to bring a case?
Corporation, the state of Michigan is plaintiff here.
Oh, the corporation, well, I think Michigan Corporations Act, I'm going to allow the standing, and everything's good. And for the reasons I've already stated for jurisdiction, it pertains to the standing as well. And the people actually have a duty to bring cases when they think that there's probable cause that crime has been committed, and it is their obligation to bring those to the courts that have jurisdiction, hence this court. And they did that. Motion to state on lawful bond conditions, that's denied for the reasons stated in the other motion that was asked to get rid of the bond conditions. And then the third part of that other motion was get a copy of the complaint, which you already got. So denied, and partially granted, and you already have a copy. So all of your motions are been answered.
No, I still have more, but Before I get to the other ones, I have,
Well, we're done for today. So you're going to be getting the date and time for the jury trial. So motions that you filed to dismiss the case and to set aside the bond. I'm going to get this jury date set, and I'll hear any other dispositive motions on that date. I'll hear the bond violation hearing on that date, and then if there's going to be a trial, then we'll go ahead and hold the trial on that date.
if he's in the, here, other demands I had to dismiss.
Sure, I have three motions that you have in front of me. I've made them.
Hold on. Judge, you still haven't heard his 3 new oral motions for reconsideration on issues you already shut down earlier today. And naturally, he comes loaded with his usual arsenal of sovereign citizen nonsense, all wrapped up like it's some groundbreaking legal revelation. Of course, Judge Slovin is more than ready for it. Every attempt Eric makes to throw out a convoluted argument is met instantly with a precise, airtight response. It's like watching someone try to play chess against a grandmaster while still learning how the pieces move. Every move is anticipated and neutralized before it even lands. The courtroom energy is tense, electric, and completely in the judge's control, leaving Eric scrambling to stay relevant.
Then I have more to make right now verbally. I have more based on, she has no standing as the prosecutor. That's one of my information. So
Okay, you know what? You just made the motion. I'll rule on the motion.
I finished.
Motion for
No, not a motion, that's the demand, that's based on my constitution.
demand motion, tomato. It really doesn't matter. A motion is you're asking the court to do something. We're demanding the court to do something. Ms. Sov, you work for the Wayne County Prosecutor's Office. Does Wayne County Prosecutor's Office have jurisdiction under the Michigan Constitution and under statutes to prosecute cases that happen and any alleged crimes that happen in the county of Wayne?
They do.
And you work for, who is your boss?
Worthy.
Kim Worthy. Kim Worthy is the elected Wayne County prosecutor for the county of Wayne.
Yes, Judge.
All right, motion in.
She has my argument though. She has still my way.
She has stand. She's doing her job.
I have not made my argument. Based on my motion.
Make her argument.
Okay, my
Make her
argument is she has no standing because she does not have a power of attorney with the so-called corporation, state of Michigan, or city of Taylor. Since she has no power of attorney that she can show to the court in evidence, she has no standing. Because she can't possibly have a power of attorney because the corporation is a non-living human, so she can't possibly have a power of attorney in the city of Taylor or the state of Michigan, which is the plaintiff here, the real plaintiff. Therefore, she has no standing.
All right, I hear you. After hearing your argument, again, denying your motion. Based on what? Based on everything you said is all legal mumbo jumbo. It makes no sense whatsoever. Like literally, if you want to know the action, it has no basis in constitutional law. It has no basis in statutory law. The fact that you're saying that a prosecutor can't do her job, she's literally hired by Kim Worthy, who is the elected Wayne County prosecutor, who under the Constitution.
And that's a wrap for today's video. But don't think this is the end of the Eric Martin saga. There's still at least one more jury trial looming on the horizon, assuming he doesn't manage to land himself in more trouble before then. Which, let's be honest, is always a possibility. If you want to follow the full story from start to finish without missing a beat, I'll leave links in the description to 2 channels that have tracked Eric's journey in detail, Old Squishy Gardener and Colin. If you found this breakdown entertaining or eye-opening, hit that like button. If not, go ahead and tap dislike. Either way, drop your thoughts in the comments, and make sure to subscribe so you don't miss any of the chaos, courtroom drama, and updates coming up next. The saga is far from over, and you'll want to be here when it continues.
Constitution of Michigan statutes, criminal statutes, revised Freakout Act, and the Michigan Constitution all coming together to give this court jurisdiction to make rulings on any crimes that happen in this jurisdiction, which they have alleged that you have done. You've got a copy of that complaint. And now they are sending their employees. Okay? If you want to talk about agency, you want to talk about power of attorney, I don't need you. When I hire somebody as my employee, I send my employee and they have what's called apparent and actual authority. Could be both, could be either, doesn't matter. That means that they send that person who has such apparent authority to go and act on, on their behalf. And Kim Worthy isn't here right now, and that's why she is an assistant prosecuting attorney. And she's here at the whim of and under the control of Kim Worthy, who is the prosecutor. Now that's a legal argument that's actually based in law. Okay? Yours was not based in any law that this court would ever recognize. Now,
I represent humans, maybe, not corporation, or you.
I didn't know, I know you're a living man, you've said. I didn't know if you were a living man, and I didn't know if man was human. I didn't know which, I didn't want to be presumptuous. I didn't say human or anything like that. But I just know that you were a living man, he said. But the court does recognize that, because again, dead people can't sit in a chair or something. So, your motion is denied, all right? And we're gonna get the court date for the jury trial in the mail, and that'll be for all the rest of the matters.